Hello everyone, welcome back to day 27 of Polity Daily Drill. Let's begin. First question. Consider the following statements about panchayats in India. The provision for establishing Panchayati Raj is explicitly mentioned in the original Constitution of India. Now, this first statement is of course wrong. Why? Because we all know that panchayats were mentioned or added in the Constitution through the 73rd Amendment Act of the year 1992. So one is wrong. Second one, the 73rd Amendment Act of 1992 provides for a three-tier system of Panchayati Raj for all the states having population of over 2 million. Now this is actually correct. Why? Because if a state has a population of less than 2 million, that is less than 20 lakhs, as per Article 243 capital B, clause 2, those states may not constitute the intermediate level of panchayat, right? Otherwise, all the states have to have a three-tier system with gram panchayat, intermediate panchayat, and the district panchayat. Whatever name you may call it is dependent on the state, but three-tier system is mandatory. So 2 is correct. Third one, the states can empower the panchayat to levy, collect and appropriate taxes, duties, tolls and fees. This is also correct. Article 243H provides for the fact that the legislature of the state may by law empower the panchayat to levy, collect, appropriate taxes. So 3 is correct. And the fourth one, states are mandated to constitute a finance commission, the state finance commission as we say, to review the financial position of the panchayat. Yes, this is also correct. Article 243 capital I states that the governor will constitute a state finance commission or a finance commission for the state every 5 years. Statement 4 is also correct. This means that how many statements are correct? C. 3 statements are correct. Moving on to question number 2. Who among the following are appointed by the President on the advice of Council of Ministers? Chairman and members of the Finance Commission. Yes, that is correct. Article 280 says that the qualification for the members of Finance Commission will be provided by the Parliament by law. Finance Commission Act provides for the qualification of the members of the Finance Commission, and they are appointed by the President on the advice, of course, of the Council of Ministers. Second one, chairman and members of Election Commission. Now, till recently, that is till 2023, this would have been a correct statement. However, in 2023, we had a judgment, Anup Barnwal case of the year 2023, in which the Supreme Court said that until and unless the Parliament makes a law, the members of the Election Commission will be appointed, of course, by the President, but on the advice of a 3-member committee comprising of the Prime Minister, the Leader of Opposition in the Lok Sabha, and the Chief Justice of India. Later on, the Parliament passed a law called the CEC and the EC's Appointment, Conditions of Service and Term of Office Act, and through the new law, a small change has been made. This committee no longer has a CJI, but now has a Union Cabinet Minister nominated by the Prime Minister, right? So this would be incorrect because the members are not appointed on the advice of Council of Ministers, but on the advice of this particular committee. And the third one, Attorney General of India and the Solicitor General. This is correct. Attorney General is a constitutional post, Article 76, of course appointed by the President. In fact, the Solicitor General is also appointed officially by the President. So 1 and 3, C is the right answer. Moving on to question number 3. Examine the following assertions regarding the DPSPs. Article 39B and C of the Indian Constitution, which are a part of the DPSP, prioritize the distribution of material resources of the community to subserve the common good and prevent concentration of wealth. This is absolutely correct and are judicially enforceable under Article 32. Now, this is where we have a problem. DPSPs are not enforceable. That is why we call them non-justiciable rights. Article 32, which talks about writs, is meant for enforcing fundamental rights. So 1 is wrong. Second one, the 42nd Amendment Act of 1976, influenced by the philosophy of socialism, added several principles to the DPSP, some of which explicitly aim to promote equal justice and to provide legal aid. This is correct. So the 42nd Amendment Act did add certain provisions to DPSPs. Some articles like 39A providing for legal aid, 43 capital A, as well as 48 capital A. These were added. Apart from it, modifications made to Article 39. So this is correct. Third one, Article 48 advocating the organization of agriculture and animal husbandry on modern and scientific lines has often been cited in judicial decisions to uphold laws related to the ban on the slaughter of cows and calves and other milch and draught cattle. Absolutely correct. Article 48, a Gandhian principle, talks about, ensuring that there is promotion of agriculture and animal husbandry along scientific lines, and also the state should take steps to place a ban on the slaughter of cows, calves, other milch and draught cattle. So 2 and 3 are correct. How many statements are correct? B. 2 statements are correct. Moving on to question number 4. In India, which one of the following constitutional amendments accorded the position of legal supremacy to all the directive principles of state policy over the fundamental rights conferred by Article 14 and Article 19? All the DPSPs, mind you. So initially, through the 25th Amendment Act passed in the year 1971, the Parliament said that in case they try to achieve the objectives of DPSPs 39B and C, which talk about what? Which talk about the distribution of material resources of the community should subserve the common good. And it also talks about how the economic policy should be geared in such a fashion that it prevents the concentration of wealth. Now, to achieve these two ideals, to achieve these two objectives, if by any chance the law violates Article 14 or Article 19, it does not matter. You cannot go to court and claim 14 and 19. This was the original idea. Later on, through the 42nd Amendment Act, the Parliament said that in case they want to achieve any of the DPSP ideals, not just these two, any of them, then it might violate 14 and 19, and sadly, there is no judicial review or immunity. This provision was actually cancelled in the Minerva Mills case of 1980. However, the first modification has been accepted, right? So it is the 42nd Amendment Act where the Parliament modified the Constitution to accord the position of legal supremacy to all the DPSPs, right? So C is the right answer. And the last question for today. A proclamation of emergency, that is a national emergency, if approved by both the houses of Parliament, continues for 6 months. Of course, the emergency provisions like national emergency or the president's rule, they continue for 6 months and they have to be approved after every 6 months. So continues for 6 months and can be extended for an indefinite period. This is actually correct. You keep on approving the national emergency every 6 months and then this can extend forever and ever and ever, right? So A is the right answer. Let's read the other options as well. Continues for 6 months and can be extended for up to 3 years. Now this is actually meant for president's rule. President's rule can be extended only for 3 years. In case you want to further extend president's rule beyond 3 years, you have to use Article 368 to amend the constitution for it. Then, so B is wrong. Then C, continues for 6 months and cannot be extended further. This is wrong. Continues indefinitely till it is revoked. This is a provision for financial emergency. Okay, so A is the right answer. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.